docket. Could we have appearances on the record, please?
Good morning, Your Honor. Mark Mag, Your Honor, former plaintiff clerk. And I also have with me my partner, Rob Boone. The plaintiff, Jessica Flintoft, is in attendance as well, Your Honor.
Good afternoon, Your Honor.
Your Honor, this is Mike Homier on behalf of the Scio Township Board. Also attending is the Supervisor, Will Hathaway.
Thank you. This motion was presented to me as an ex parte motion, which I did not grant. I don't normally grant those. Instead, set it for a hearing today, and I have it kind of, well, we call them briefs, but obviously it's not very brief. And I understand some of these things weren't filed with the clerk's office. So tell me where we stand today, just in terms of procedure, and we'll go from there. Thank you.
Thank you, Your Honor. And just to address that last point, I think the only item that perhaps through an oversight of my office wasn't filed was a brief in support of TRO. Fortunately, our exhibits and our facts were all out in motion. The brief was just to lay out the fact. So
you're cutting in and out, sir. You're cutting in and out. I don't know. We're having difficulty hearing you.
Turn my volume down a little bit. Is that it?
No. I don't know if it's your connection or what, but you're going in and out.
I'm at the Dykema office in Lansing.
Well, and I'm in the courtroom in Ann Arbor. What I'm telling you is you're going in and out.
Understood. I'm trying to figure out when
we're getting feedback on this as well.
Mr. Mag or Mark, maybe you should use your phone for the audio.
Yes. Is there a number I can dial in for that?
That phone number is 646-876-9923, and you'll enter the same meeting ID number.
Hello, Your Honor.
Okay, that's much better. So, Mr. Homier, I did not know, of course, who you were, because I don't think you had any notice of this request on an ex parte hearing. And I have both your response to the brief, et cetera. And one of the things you noted is that for today's hearing that the brief had not been filed. There wasn't anything in terms of the statutory or case law support or the legal argument Do you want to proceed today with this hearing, or do you want an adjournment for a week? You let me know what you would like, sir.
Thank you, Your Honor. This is Mark Magyar, the movement for the plaintiff. I'm prepared to proceed, and I think I can clarify what's transpired and why I don't think it prejudices the hearing. But I would also.
Oh, no, I was, Mr. Magyar, I was talking to Mr. Homer. He's the one that
Oh,
pointed out
understood.
there. hadn't been
I'm
agreed.
sorry. I thought you were asking as far as the movement. I'm
No,
sorry.
I'm asking Mr. Homer, because I was looking at his brief saying that hadn't been filed. There's no case law, but you're indicating that there was an error and you're trying to get it filed, and I don't know if it was filed this morning or not. Mr. Homer, did you want to proceed with this request today? Again, I denied it as an ex parte. I always think it's important to get both sides of a story. Are you ready to proceed with their request on a TRO today, or do you want me to put it over 1 week for you to review apparently whatever the brief is?
Thank you, Your Honor. I had an opportunity. We got the brief at about 11:15 this morning, so I've had an opportunity to review it, and I'm comfortable in proceeding.
All right, Mr. Magyar, I need to tell you, it has just been given to me. I've been on the bench since 8:30 this morning, so when a brief comes in at 11:15, particularly with all the documents that you've been attaching, I have not had the opportunity to review it. However, in 31 years, I've certainly heard many, many motions about requests for temporary restraining orders. If you are comfortable with me proceeding without having had the opportunity to view a brief that you just, I have not had a chance to look at it. I can't stop in the middle of hearings. Do you want me to proceed today, sir?
I do, Your Honor, and I think for the reasons that will hopefully be articulated throughout the hearing today, I think it'll turn out that, for the reasons you've just stated, that what's in the brief versus what's been presented earlier, the substance was earlier, and it'll be factors that you're well familiar with in terms of TRO relief.
Okay, thank you. So if both of you concur, we can go ahead and proceed. I'm happy to hear your argument.
Thank you, Your Honor. And first of all, I would like to state that I understand it's been a long morning and that you've made a provision in your calendar for us, so thank you for that, and I will try to hit the highlights and not, recite chapter and verse our pleadings and motions that were filed in this case. And I think it can really be boiled down to what I think is the main issue we're here to talk about today, regardless of what else is going on in the complaint, is this issue of the current needs of the township from a finance personnel, whether that be vendors or internal staff, to complete necessary services in the realm of accounts payable and payroll. And this issue long predates me, my involvement, the filings in this case. It goes back more than a year, and we can see those in township minutes. At one point in around March of 2021, so more than a year ago, there was at least at one time a consensus that there should be a new finance director to someone who is sort of a little more credentialed to catch up with the complexities that are now facing the township that maybe weren't 30 years ago when the existing staff was in place. And so that's been no secret. That's been an on and off tabled agenda item, matter of discussion for more than a year. But what happened was things really escalated quickly recently in terms of that void and that need. The first thing that happened, and I'm not going to go through all the background, I'm going to try to limit the pertinent background, but the township decided in about July of last year to go back to what's called the township manager or management style of government, and that there hadn't been a township manager for a couple of years. And that was considered by all to be a very positive development, especially with, I don't think my client, the clerk, would make any bones about me saying this. The real internal problems of this board that hampered the ability to really serve the residents. And so it was viewed positively by all that there was going to be this experienced manager
And so it was resolved, I think unanimously in July to have this position. By October, then they went into a recruiting function. I think by October they agreed that they were going to, on a candidate, David Rowley. And to the extent testimony is needed, and we'll get to that, whether this is a TRO or a PI hearing because of some of the arguments in the response, but we do have some testimony available from the HR employee from the township who was involved in searching for a candidate for a township administrator. But David Rowley is unquestionably supremely qualified individual. I mean, I don't think anyone could dispute that. He's got 25, 30 years, including government finance. And just a couple of snippets from when the Sun-Times reported on his hiring. The very first line of the article was, December 1 will mark a new beginning inside Township Hall. That was referring to David Rowley's hire. And the supervisor, Mr. Hathaway, provided a quote in the same article that this new position was redesigned to emphasize operations oversight. And they went on to say that they were hopeful that Mr. Rowley, that the, quote, the intent is that he would help the supervisor, clerk, treasurer, trustees, and staff to work more effectively as a team so that they could better serve the residents. So that was the background of this hire. It was supposed to be a whole new way of operating government, have someone very experienced, have operations oversight, someone who could kind of bring together this, by their own admission, dysfunctional board. And that hire was on December 1st, so we're talking 4 or 5 months ago, 5 months ago. And then in November, right around the same exact time that the administrator comes, the finance director moves from finance director to deputy treasurer. And there's a couple of significant points about that. This individual was the one who, there had been some agreement months earlier that they would like to transition her in favor of someone a little more credentialed for the finance director role. And the plaintiff, in this case, Justice Flintoft, agreed that she could transition to deputy treasurer because that would allow the hiring for this void, this vacancy of a much needed position in finance director. So Ms. Eckler did, in fact, switch roles, but then nothing happened to fill the finance director, which, as we sit here today, remains a vacant position. And that put all the pressure on only one other member of the finance team, and that was the finance manager. And she does great work. She's very skilled. And unfortunately, she's had a tremendously sad, and I, of course, would never get into the particulars on a public hearing, but she's been on family time off since March 9th. So just to recap before we get into the present, you had what was already a consensus of needing more robust financial assistance going back more than a year when there were 2 people on the finance team. Then you remove the finance director, who there was already a consensus should be replaced, but now that spot is vacant, and the only person you have doing this work goes on leave. So we enter the circumstance we find ourselves in as critical functions, namely for this today, accounts payable and payroll, not being adequately addressed by qualified staff. And so there was a meeting about this almost within a week of time after losing the finance manager to family health issue or family care issues. The treasurer, the clerk, the township administrator, and the supervisor all got together and they met on March 15th. And all 3 of these individuals, clerk, treasurer, administrator, told the supervisor, we've come up with a plan. We need someone to do this. We've got Raymond Robson on board. The township administrator also got quotes from Plant Moran, did his due diligence. Again, this is the recently hired administrator to have operations oversight. And they take it to the supervisor and he says, well, I don't really know if we need to do this. And so they meet again the next morning. And so there's nothing being hidden here. Right in front of the supervisor at a March 16th meeting, the clerk and the treasurer signed an agreement with Raymond Robson to provide payroll and accounts payable services for the limited period of March 17th to June 30th, for about a, what was that, 3.5 month period. And that was, a bridge, a gap filler to try to see.
Mr. Magar, Mr. Magar, we really do need to focus on the posture of the case at this point. You're here asking for hang on, let me finish so that you know what I'm asking you to do, sir. You're here asking for a restraining order at the outset of a case that you filed. You filed a 5-point part complaint. I'm trying to count how many pages you have filed. Obviously, I think as an attorney, you would agree with me that the other side doesn't agree with every word that you've said in the numerous things that you've filed. That's why we have trials, and that's why we have, that process. So you're here at the outset seeking this relief. So what you need to do is outline specifically the relief that you're requesting in a temporary restraining order, and then you need to address the 4 factors, which are: 1, the likelihood that the party seeking the injunction will prevail on the merits. Tell me why you feel you can meet that threshold. 2, the danger that the party seeking the injunction will suffer irreparable injury if the injunction is not issued. Again, address that succinctly. 3, the risk that the party seeking the injunction would be harmed more by the absence of an injunction than the opposing party would be by granting of the relief. And 4, the harm to the public interest if the injunction is issued. And if you could focus your argument today, sir, in accordance with the relief you're requesting and the applicable law, I would be most appreciative.
And I appreciate that direction, Your Honor. We are to the point, and I will focus on those matters of talking about this Raymond Robson contract. That's what we were asking not be canceled and terminated under a TRO. That's the contract that the administrator recommended. That's the contract that the treasurer and the clerk signed. And the critical point for likelihood of success on the merits prong is the township's purchasing policy, which we provided. And under Section D of that policy, it gives any of the officials on the board, here we have 2 of them, the right to purchase services, even individually, but again, we have 2 of them, when they're, quote, emergency services. And we think that is the crux of the dispute today that the other side disagrees with. And that was, frankly, my reason for going into the background and what the township administrator thinks about this, is because I think Your Honor will have to decide, and it's count 1 of our complaint, is a declaratory, actual controversy as to whether there's an emergency facing this township in their ability to process payroll and accounts payable, given that they have no finance staff right now. And so the contract we were asking to, on a TRO basis, to not be canceled by the board is the one that the clerk and the treasurer put their names on under Section 2D of the township's purchasing policy. When we filed the complaint on April 11th, that was the status quo. On April 12th, the board, knowing that the complaint was filed, knowing that this hearing was scheduled, nevertheless did in fact cancel that contract. And they did so on the basis that existing staff, including the deputy treasurer, were skilled enough to perform these functions, which we do not agree and do not believe is the case. I'm going to go on to the factors based on, the direction I've received things, and I thank Your Honor for that. The likelihood of success on the merits is the township's purchasing policy, coupled with the fact that there does exist an emergency basis for need of an outside vendor to perform those services right now. So pursuant to the emergency that exists, Section 2D of the purchasing policy allows the plaintiff, also with the treasurer who signed it, the authority to enter into that contract with Raymond. And that's why, contrary to page 1 of the township's response brief, we do not concede, we contest the authority that the board says they had to cancel that contract because it was validly entered under the emergency powers of these individual officers. The irreparable harm to be suffered, I think, is threefold. One is that the clerk's purchasing power under Section 2D of the policy is being interfered with, as is any individual officers who tries to exercise that authority, only to have the board undo it. Second, we've cited MCL 41.75, which is the clerk's statutory obligation when she's cutting checks for accounts payable to be essentially certifying the appropriateness of those payments, which with unqualified staffing and a refusal by the board to follow the administrator's recommendation to hire an entity like Raymond makes it impossible for her to, with any faith, who, by the way, is required by law to put up a personal bond, impossible to, with any faith, certify these things as being accurate when she signs these checks. And then in addition, you've got the township farm. You've got employees of the township who are relying on payroll. You've got vendors of the township who are relying on being paid on their invoices. And right now, there's not qualified staff to handle these positions. Really quick, moving to the harm to the township, I think the only harm that they're contending that they would have is the price of the contract. And yet they've provided in your response, Your Honor, what they contend is how great the general fund is. I find it hard to believe that the township is being harmed by the expertise of a firm like Raymond Robson for a 2 and 3.5 month period, having their eyes on the accounts payable and payroll while the finance staff is decimated. I don't see how that's harmful to the township. And then finally, public policy, I think, has to favor our motion. Public policy would be when you're dealing with taxpayers' money, that you've got qualified people handling it, and that when you've got officers exercising authority under internal township policy to enter into contracts, that those are respected and not improperly invalidated. So those are the factors, and on that point, Your Honor, what I just said was basically what was filed today, and it was prepared. It was not prepared after April 11th. It was somehow inadvertently not with the April 11th packet. So none of the exhibits or the facts we're relying on, but those 4 factors are what were detailed in that brief. And I do want to just emphasize one more point, unless the court has any other questions, is the administrator felt so strongly about his being marginalized by this board that he resigned on April 12th. Mr. Rowley, who was touted just 5 months ago by this board as being the operations oversight person who was going to bring the board back together, and who has 25 years experience in government finance, when he over and over again had his recommendations flat out ignored, he got chewed up and spit out by this board within 5 months of the hire. And it was his recommendation to enter this Raymond contract. And one of the things, two important points that I need to address that were in the response, because they make them out to support their position, and I really don't think that it does support the township. One is that they say, well, the administrator came to us on April 12th with 2 options, option 1 and option 2. And option 2 was to handle these matters with internal existing staff. And so we took the administrator up on his option 2. What's the problem? He's the one that offered that option. That is not at all a fair reflection of what happened. On March 22nd, the board told the administrator, come back to us with what a proposal would look like for doing these functions, these accounts payable and payroll with internal staff. He followed the mandate of the board and issued a questionnaire to internal staff. And he put together what the board asked him to do in option 2. And the last line, which is not in our opponent's brief, is he said, I've evaluated these options and I recommend staying with the Raymond contract. So basically, you told me to look at what we could do with our internal staff. I looked at it, and it's not viable. It's inferior. And what the board has turned that into a thing, the administrator presented us with two options. We chose option two. And that's not what the administrator was saying, all the way to the point where in his resignation memo, which we provided to the court, he says, there's a fundamental disagreement with this board on government, on the finance and how to use the taxpayers' millions of dollars. And I strongly urge on my way out, I hope the board will hire someone with at least a business management degree or a CPA for this role. So not only did he not recommend this option two of internal personnel, he said, when I go, I really still hope you hire someone who has the qualifications to do this job. And then that was one point, that this option two really was not an option as far as the administrator was concerned. He was just reporting to the board what they asked to hear about. And then the second point is that they've argued that the standard sort of stock terms in the Raymond contract say that the township was allowed to do what they did, which was to end this contract. That's frankly a red herring. All that means is that Raymond can't sue for breach of contract. That has nothing to do with whether they followed their internal policy, which was that the clerk and the treasurer, who both voted against this cancellation on April 12th. So they stuck to their original, as did the administrator, their original proposal. And so, in sum, the act by the board to attempt to moot the relief we were seeking by taking action did not moot the emergency that exists. It did not moot the emergency power to secure vendor services under the purchasing policy. And the TRO that we are asking for is for no interference by the board with the emergency purchasing power under Section 2D, specifically in the short term with respect to the accounts payable and the payroll function that Raymond Robson had been performing all the way up until April 12th under that contract. And if Your Honor has any further questions, again, I thank you for your patience in hearing us after a full morning and resolving some of the difficulties and directing me to the factors. And I'd be happy to address anything.
Thank you, Mr. Magar. Mr. Homer?
Thank you, Your Honor. I think what you've heard from opposing counsel today amounts to, well, we're disappointed in the policy that the Township Board has chosen to follow. They haven't cited one rule, one ordinance, one statute that has been violated by the Township Board in terminating the contract. When we look at the factors, and you look at factor number one, substantial likelihood that plaintiff will succeed on the merits. First, with respect to the purchasing authority. The purchasing authority is an emergency measure that should be used in emergencies. I question the validity of it, but assuming, for the sake of argument for today, that there was an emergency at the time when it was executed, that contract is in the name of the township. That is, the township is obligated. So on March 22nd, after that contract was executed, the Township Board got together and indicated that they were prepared to terminate that contract. They had every right to do that. Pursuant to MCL 41.2, the Township Board has the authority to contract for services. Not the clerk individually, not the treasurer, not the supervisor, not any one of its trustees. With that comes the authority to terminate contracts, and there is a termination provision. Raymond Robson, as you've heard, is not even a party to this action. They have not contested the termination of that contract. In fact, they have acknowledged that the termination has occurred and that they will be paid by the township through the date they've been providing services. What the clerk is requesting here is unprecedented, and that is for the court to intervene in the policy making that the board determines is wise for its constituents. You could look at any given policy and think, well, that's right, that's wrong. The relief is not at the courthouse. The relief is at the ballot box. So we have to look at the purchasing policy because they've cited that as their sole authority now. And that purchasing policy doesn't say at all that the township board cannot terminate contracts that are entered into pursuant to that purchasing policy. So the board on March 22nd said, well, we're going to terminate this agreement if the administrator can come up with a plan. And they directed the administrator to come up with alternatives, which could involve outside services, and that the board would terminate the contract with Raymond Robson effective April the 12th. The clerk then files this lawsuit on April the 11th. On April 12th, counsel for the clerk sends the board a letter saying, well, you can't do this because we filed a lawsuit. But the board had already sought to terminate that contract. So when they got a report or alternatives from the administrator, there were two options, option one and option two. Option one was the continuation of the contract with Raymond Robson. Option two was an alternative using inside staff. No secret, the administrator preferred option one. Township board said, no, we're going with option two. They have every right to do so. There's nothing that you've heard today that prevents the township board from deciding policy, and they did it on a majority vote. Now, I understand that the clerk may be disappointed with the outcome, but the board has the authority to terminate that contract, and they did. So on the first factor, substantial likelihood that plaintiff will succeed on the merits, they fail. Without a question, they fail. Whether plaintiff will suffer irreparable injury, the plaintiff isn't even a party to the contract. She may have signed it on behalf of the township, but that contract is in the name of the township, not the clerk individually. There is no standing here. There is no irreparable injury. There is no actual proof that the township hasn't met its accounts payable or paid its employees. It has a very healthy general fund budget, and it's making those payments. The third factor, whether the hardship suffered by plaintiff outweighs the possible hardships to defendant by not issuing a preliminary injunction. This goes to the staffing issue, and you've heard some of that today where plaintiff's attorney makes the argument that, well, we don't have enough staff, we don't have enough staff. The legislature in 2011 dealt with this under 41.3 small a. And that statute says that beginning on the effective date of the amendatory act that added this section, a township board shall not adopt an ordinance that includes any minimum staffing requirement for township employees. Any provision in a township ordinance adopted by a township board on or after the effective date of this amendatory act that added this section that contains a minimum staffing requirement for township employees is void and unenforceable. What the plaintiff is attempting to do is to get the court to enforce a minimum staffing level. Now, again, I understand disappointment with policy decisions, but the remedy is not at the courthouse. The remedy is to advocate for public policy, support other candidates at the ballot box, do whatever you want. But this is what democracy looks like. There was a vote, the board took it and terminated the contract. Finally, Your Honor, you asked whether the preliminary injunction, or have to ask whether the preliminary injunction will help or harm public interest. Obviously, there's a separation of powers here. The township board is given the right to map out its own policy, and they've done that, like it or not. Well, there may be remedy at the ballot box next election for that. I don't know, nobody knows. But the public interest here is harmed when a plaintiff comes to the judiciary and asks them to then involve itself in the executive or legislative function of a local municipality in deciding not only policy issues related to staffing requirements, but also, think of this, to vacate a termination of a contract that the board had every right to terminate. That is unprecedented. And I don't think that the court should be in a position of trying to determine whether a township should or should not enter or terminate contracts for services. And Judge, I'm happy to take any questions.
Thank you, sir. this is your motion, Mr. Magar. You are entitled to rebuttal, and then I'm prepared to rule on your motion
Okay.
today.
Okay, I'll be very brief, Your Honor. One, this motion has nothing to do with minimum staffing requirements. We've not asked for there to be staff. We did expect, based on prior discussions, that we're going to have more robust finance staff and that it's needed. But that's all the more reason why, if there's no minimum staffing, then we shouldn't be interfering with an official's ability to hire outside vendor contracted services for the work that needs to be done when that authority is properly executed under the purchasing policy. By the way, the purchasing policy also provides for the supervisor to appoint a purchasing agent, and I think there is documents in the township file that he did, Mr. Hathaway did that with the administrator, Mr. Raleigh, who recommended this Raymond contract. In terms of the last point about vacating, really what we've asked for, when we filed and they changed the status quo during the filing, we were asking that the contract not be canceled. And if Your Honor doesn't want to vacate, even though we think it was an improper ruling, or I'm sorry, an improper decision, what we're really asking for is not to interfere with the township's purchasing policy, which gives every official the ability to contract for emergency services. And here's the real problem why we sought judicial intervention. I don't think it benefits anyone for the next day after the April 12th meeting, the clerk to say, well, the emergency still exists and I still have emergency power. I'm just going to sign another contract. And then the township's going to say, we still disagree with you. We're going to cancel it at the next meeting. And around and around and around we go to the benefit of no one. And that's why we sought judicial intervention. And that's why, frankly, we thought that the fact that the township board knew that this hearing was going to be held and felt that 9 days was too long to preserve the status quo, to just seize the outcome of today and continue having the expertise of Raymond under that contract, I think really demonstrates the sort of the issues that are really in play and the power struggles that are in play here. Because when I wrote that letter, and contrary to the representation of Brother Counsel, I didn't tell the board what they could or could not do at that meeting. I told them, heads up, there is a lawsuit, there is a hearing date, it's April 21st, 11:30. If you can cool your jets until then, we, quote, respectfully request. That doesn't sound to me like telling the board what they can and can't do. We respectfully request that you table this decision, like they've tabled for months the decision whether to hire a new finance director, until Judge Connors can weigh in on this issue and maintain the status quo, is what I said in my letter. They didn't follow that request, and I didn't tell them that they weren't allowed to have their vote at the meeting. And that's what they chose to do, which again, I think is a demonstration of some of the dynamics going on here. And the last point is there was an issue a reference on page 15 of the response about evidence. We are prepared to put in evidence. If we want to turn this in from a TRO motion to a preliminary injunction hearing, we would want that opportunity. Like I said, there's at least the clerk herself and Diane Benson. But really, I think the emergency, and there has been so many MLive articles going back from before my involvement, and we've attached at least one of them. Your Honor, I don't think there's a dispute on what the emergency is, that the finances are a mess in this township. And when you take away the only two people that were on that staff, I don't think it's a tough leap to make, but we're happy to put in evidence on the emergency that exists, which was the authority under which the Raymond contract was signed, and that we still believe another vendor, if not reinstating Raymond, is going to be needed. But again, we didn't want to go round and round in a cycle of emergency contracts that the board canceled without intervention.
Thank you. Anything else from either side?
So I guess, Your Honor, I have to point out, and I will be done in less than 3 minutes, but the motion that the board made on March 22nd to maybe terminate this Raymond contract said they would terminate it if one of two things. The finance manager is able to carry out those duties. That's a no. she's not back full-time from leave yet. Or the township administrator is able to create an alternative plan for accomplishing these tasks using the township's full and part-time employees, including the deputy treasurer. That's a no. And the township administrator said as much when he listed what that option might look like and recommended keeping the Raymond contract. So the very two things that this board put in their March 22nd motion, which would be one or the other had to happen to cancel the Raymond contract, neither happened. They're saying the second thing happened, that there's qualified staff, and that's against what the administrator said in his memo. And now I promise I don't have any more follow-up here.
Thank you. Let me rule on this request for a temporary restraining order. And in ruling on it, let me give you my observations and personal view as it relates to not only this case, but similarly situated occurrences. There's clearly a problem within the individuals elected by citizens in Scio Township in their ability to communicate and to reach consensus. Those officials, just like any other township official or city council or state legislature or state senator or federal legislators or judges like myself, when we run for office, when we are elected, when we are sworn in, we take an oath of office. And when we take that oath, that is a promise that we accept the responsibility that has been given to us by the citizenry we serve to behave in a way that is not in our own, for our advancement of our own egos or our own agendas, but to in fact be selfless. Mr. Homer makes an excellent point that in fulfilling my oath, it is not appropriate for any judge to micromanage, step in, become something that we were not elected to do, and that is to run a local township council or board. The fact that there may be a disagreement over a contract does not rise to the level, legally, factually, or even within our system of government, that a judge should be stepping in and making those determinations. If I were to grant this TRO, what would be the prevention of the next contract that comes up? The janitorial contract that comes up? What would be why would I not say, fine, Ann Arbor City Council, bring anything you have that you disagree on? Or the Board of Commissioners, or the Ypsilanti Township Trustees, or the City Council of the City of Ann Arbor. Why not weigh in on what's happening with the legislature and start to take over superintending control? Even among judges, there is an opportunity for parties to ask for the Supreme Court to step in on a particular judge for superintending control, which the Supreme Court is very careful about ever doing. Because what happens is, if one side doesn't like what happens in the other side, then they go and ask someone else to do something they weren't elected to do, nor should I be doing it. And if I were to step in and say this contract is void, that would be subject to appellate review. Should we have 3 appellate judges decide whether a contract for services in one township is something that should be reviewed? That would then go to the Supreme Court. then I agree with counsel that the request that is being made to me is outside of the parameters, certainly of a temporary restraining order. There are factual disputes about what's happening, and there are legal limitations of what a court should do when parties feel aggrieved and file a complaint. What is not before me today is a motion for summary disposition on the claims, but simply whether I should agree with the plaintiff and grant their request without even a full hearing on the merits or the credibility or the application of the law. None of the four standards that allow me to grant such an extraordinary request have been met in this case. I agree that there are serious issues, both legally and factually, whether or not there would be prevailing on the merits of this. The harm that may be caused, no one is going to die. The few times I've granted a temporary restraining order is literally when I thought someone might die. If there's been major pollution in rivers, or someone might literally lose their life if we don't do something in an emergency basis. A dispute of personalities among people whose obligation is to serve the public is not an emergency. And the public harm is created by those who don't fulfill their obligations of responsibility to the oath of office that they took. The remedy for individuals who fail to do that is, as Mr. Homer indicated, to let people vote and elect officials they have confidence in. Motion for the temporary restraining order is denied. For those reasons, Mr. Homer, if you would submit an order that indicates denied for the reasons stated on the record. And I don't know what will survive from the basic complaint itself, but as I said, I don't have a motion for summary disposition in front of me. If that occurs, I'll deal with that. If we need to have, if there are areas